21 News, your place for politics. This is Decision 2024.
Good evening, I'm Lindsay McCoy, and 21 News is your place for politics. We are tonight inviting the candidates vying to become the next Mahoning County prosecutor to debate. Now, the incumbent Democratic candidate, Gina DeGenova, she's looking to retain the seat that was appointed to her when Prosecutor Paul Gaines retired. Her challenger is Republican and defense attorney Lynn Morrow. Ladies, thank you so much for agreeing to debate.
Thank you.
The format is simple. Each candidate will begin with a brief 1-minute introduction of themselves. A coin toss prior to this debate determined who would get the first question, and that is Gina. This is an open format, no timekeeping for the answers, but I do reserve the right to wrap things up and move along to another topic. We will conclude by giving each candidate 2 minutes for closing statements. With all of this said, let's get right to our first question. Gina, over the past several years, we have seen attitudes toward criminal prosecution shift more towards rehabilitation as opposed to punishment. In your opinion, how much of a prosecutor's job is it to punish, and how much is it their job to rehabilitate?
Well, I think that there's a combination of both of those factors to consider as a prosecutor. You know, we have diversion programs that are in place in Mahoning County. Those diversion programs are designed to assist individuals who qualify and who could, who could benefit from treatment and from counseling as a result of the crimes that they have committed. So, for instance, we have drug court. We have Judge Durkin. He runs an amazing drug court. There are instances where we have addicts, family members, no family is immune from it, and they may be committing the crimes because of their addiction. There are instances where we will then have a prosecution or an indictment on a drug crime. If they qualify for drug court, they'll go in through the program, and if they complete their course of treatment, then they will end up with a dismissal of their case. There are instances where I would welcome diversion programs, but at the end of the day, my main duty is to keep the community safe. My duty is to prosecute those who violate the law, and my duty is to do it to the furthest extent of the law. We do that every day at our office. You know, every day, each year, we have over 1,000 cases that we have handled. Last year alone in 2023, our office had 1,000 cases that we processed. Out of those 1,000 cases, we had a 98.6 conviction rate. I think that that's very important, and it's indicative of the work that our office does and the dedication of our prosecutors. Because it is honestly sometimes, it's a balancing act, because we want to help, but we have to have consequences. You know, I've told my daughter many times as she was growing up, actions have consequences. And sometimes, even though you try to help, at the end of the day, there are individuals that don't want to take the help. And it's our job to make sure that there are consequences so that the community remains safe. I'm committed to doing that as prosecutor. I created a special victims unit within my office where we prosecute and protect the most vulnerable victims of our community. I think that that's important because there is a multifaceted approach to this. Not only do we have to give those individuals a voice heard, but it's very important that the individuals in our office who prosecute them have the empathy needed to make sure that justice is served. So I can assure you, from my perspective, we try to help when we can. But at the end of the day, our job is to keep the community safe. It is an obligation and a duty I take very seriously, and I will continue to do that as prosecutor.
Lynn?
Thank you. So when you're looking at the issue of punishment, it is the judge who decides the punishment, not the jury, not the attorneys. The problem we faced in Mahoning County is the disparity in the sentencing recommendations coming from the prosecutor's office. Nearly 2 years ago, when I announced that I was going to run for prosecutor, I said I thought it could be done better, and that's why I'm running, because it can be done better. When you look at the worst of the worst offenses, those are the ones where you want the harshest penalty. And in Mahoning County, on murder cases, what we saw was that 15% of those murder cases are ending up dismissed or not guilty. That rate has remained the same over the past 2 years. That has not changed. If you were charged with murder in Mahoning County, murder, you take a life, the concept of the sanction is, the penalty is life in prison. Not in Mahoning County. 61% of the time in Mahoning County, the prosecutor reduces that murder case to a non-life offense, which means that individual is going to get back out in a couple years. So we're only getting life sentences in Mahoning County for murder cases over the past 2 years in 24% of the murder cases that have been charged. Columbiana County, 75%. Trumbull County is over 55%. So my big concern was what I saw with violent offenses being pled away. The lower level offenses where treatment and probation and counseling can help, I think everybody agrees with those nonviolent offenses, those treatment programs are critically important. But with the violent offenses, we're simply failing in Mahoning County. And when I announced I was running and said cases were being delayed, dismissed, and lost because the rules weren't being followed, Attorney DeGenova had 2 responses. I don't plan to change anything, and I don't know what she's talking about. And for the past 18 months on the campaign trail, she has consistently said, I don't plan to change anything, and I don't know where she gets her numbers. My numbers are from the Ohio Supreme Court's database and from the Mahoning County Clerk of Courts. And after 18 months of hearing these numbers, dismissals, reductions on the most violent offenses, 30 days before the election, my opponent finally said, when I took office, I said I was going to review everything and change everything. That isn't accurate. 18 months I've heard, I'm not changing a thing. We're pleading away the most violent offenses so that the sanctions and the penalties are the lowest in the Tri-County area. It's not being done that way other places. We can do it better. We need to set up a database on plea bargaining where we can track what the reductions are and what the recommendations from the prosecutor's office is. But we have to stop on our most violent offenses having no regard for getting those life sanctions for someone who takes a life. We can coordinate with law enforcement better to make sure that we have the evidence in place that we're not having those dismissals and delays and not guilties. In the past 2 years since she's taken office, there have been 2 murder cases vacated in the Court of Appeals and 1 major rape case because the rules weren't followed. So my focus is on making sure the rules are followed and the law is followed so everyone has confidence in the outcome, and making sure on the worst of the offenses, the prosecutor's office is going for that maximum sanction. It's not what's happening now.
Gina, would you like to respond?
Absolutely, Lindsay. So there's so many things that my opponent talked about. I'm going to try to address all of them because I have taken some notes. Her stats that she's been using, this 15% figure, I continue to ask where it came from because I don't understand where the number comes from. I can tell you, we keep our statistics. I have a program and a database that we already have in place. My opponent says she wants a database. We have a database. It's called Matrix, and we track all of our cases, and we know the cases that are indicted, they get entered into the system, we follow it to disposition. So when you're talking about dismissed murder cases, I have been prosecutor for 21 months. In my time as prosecutor, we have indicted 35 homicides, okay? 35 homicides. Out of those 35 homicides, we have had 1 case that was dismissed, and that was after the conviction of a co-defendant, and we had 1 case that was acquitted. Now, if you want to go back to a case that was indicted in 2022, we did have 1 dismissal this year, and that's because the guy died. So I clearly can't prosecute and obtain a conviction over a man who ceases to live on this earth. So I am not able to do that. What I can tell you is that we look at our statistics, and I'm really glad that she mentioned that she looks at the Supreme Court, because we understand that the Supreme Court does have statistics. These statistics have been used in many prosecutors' races over the years, one of which was the race between Paul Gaines and Martin Desmond in 2020. Martin Desmond used Supreme Court numbers in order to argue about Paul Gaines' stats. So we spent a great deal of time looking at those numbers. And what we found is they're apples and oranges. You can't use the numbers provided by the Supreme Court for the purpose that my opponent is using them for. The reason why? Because what we learned was the Supreme Court looks at dismissals by case numbers, not people. For instance, in the case of Robert Seaman, my opponent represented this gentleman. She should know the case. Mr. Seaman was accused of raping a young girl, and then he was accused of killing her on the eve of trial along with her grandparents. Mr. Seaman then, close in proximity of time to the date he was set to go on trial for their murders, he jumped off the 4th floor of the courthouse to his death. We obviously, since the man died, we had to dismiss his pending cases. There were 3 related cases that were pending on Mr. Seaman. The Supreme Court would have considered those as 3 dismissals. For my purposes of my statistics, I don't consider any of them as a dismissal for purposes of reporting outcomes that weren't desirable. Because the point of a prosecution is to rid the community of dangerous criminals. Mr. Seaman did that himself. So we got the desired result, which would be to get Mr. Seaman off the streets. So also with regards to the dismissal rates at the Supreme Court of Ohio, the Supreme Court counts dismissals of, like we talked earlier, diversion programs, okay? The diversion programs are counted as dismissals even though they're dismissed after a complete course of conduct is over. So you have, and one more final point, and I can always go back after this, but my opponent is implying that if we reduce a murder case to a manslaughter, that the individual is getting a slap on the wrist. That could be farthest from the truth. My opponent knows this. She represented a man by the name of Grant Cooper. Grant Cooper was involved in the murder of Vivian Martin. Mr. Cooper pled. He was indicted on murder, and he pled guilty to manslaughter. He was sentenced to 28 years in prison. So there are reasons why we reduce our cases from murders to manslaughters, and the individuals responsible still get extensive sentences.
We're going to move on to the next question.
Okay.
We have a lot to get to here.
If I can,
real quick.
on the dismissals, every courtroom in the Mahoning County Court of Common Pleas has a jury book with their jury trials. Since she's taken office, 21% of the trials that have occurred have been not guilty. There have been 4 dismissals of murder cases and 2 not guilty on murder cases from Mahoning County's clerk of court. So these aren't from the Supreme Court, and when we calculated the statistics, we removed diversion program cases and cases transferred to another courtroom.
Let me wrap this up.
I know, but can I respond real quick, though? Real quick. It would be very
She
quick.
had her moment to respond. We're going to move on to the next.
Sure.
Lynn, this is to you. On to the opioid epidemic and rehab. From 2014 to the fall of this year, the opioid epidemic has taken 1,240 lives in Mahoning County to date. While the state of Ohio is seeing a drop in overall deaths in 2023 and to start within this year, the Mahoning County Mental Health and Recovery Board tells me that there's still a lot of work to be done to stop this epidemic. When prosecuting drug crimes, would you treat addicts the same as traffickers, and how would you draw that distinction?
So the Ohio Revised Code, Ohio law, already draws a distinction in the sanctions and the penalties between those who traffic in drugs and those who are addicted to drugs. So yes, it's already built into Ohio law, but more critically important, there has been some litigation suing pharmacies for the opioid epidemic. One Ohio was a class action lawsuit that Mahoning County participated in and got some, what I will characterize as minimal funds to address that opioid epidemic. Approximately 8 years ago, a local pharmacist came to the civil division of the prosecutor's office with a binder of records and documents saying Mahoning County should pursue lawsuits against those who have contributed to the opioid epidemic. They literally pushed him onto the elevator and ignored him. Trumbull County filed suit. Lake County filed suit. They got a verdict of over $600 million to help with treatment programs and addiction services. Mahoning County got nothing from that. That $330 million that Trumbull County got was in addition to the dispersals from the One Ohio class action. We could have taken a much more proactive role in holding those who have contributed to the opioid epidemic accountable, and we could have had an additional $300 million to address treatment and programs to combat the opioid epidemic in Mahoning County.
Gina.
Yes. So to address those statements that my opponent made, and then I will get to some of the work that we've been doing about the drug problem in Mahoning County. So the individual that my opponent referenced, I am not sure who that is because it was under a former administration. If members of the office did not meet with an individual, I have no knowledge of that. 8 years ago, I was an assistant prosecutor, so I guess, you know, maybe my opponent would have to talk to Paul Gaines. However, what I can tell you is about the opioid litigation. So it's a very interesting story. So the lawyers who were responsible for the opioid litigation are actually two very close friends of mine. We went to law school together. And we met with them, and actually I was in the room along with Prosecutor Gaines and the Board of County Commissioners, and it was Frank Gallucci. And so Frank Gallucci comes in, and you know, after we talk a little bit and catch up about, you know, kids and lives and, you know, the things that you do when you see an old friend, he said, I got this idea, and I want Mahoning County to be the lead people on this case. We're going to be suing these drug companies. And you know, we talked about it at length, and it was a risk. For us at the time. We didn't know what we know now. What I can tell you is that ultimately Prosecutor Gaines made the decision to recommend against becoming a party in that litigation because at the time we had a concern that if we lost, we would be responsible for the legal fees and costs associated with that litigation. When you talk about class action lawsuits, oftentimes the fees could be extensive and the clients are supposed to pay for them. So he opted not. As it turns out, it was a mistake. But the good thing about that $300 million, Mahoning County still gets a portion of that amount of money. Now, would it have been great, looking back, hindsight 2020, to have been the lead party in that case? It would be. But sometimes you have to make decisions, as Prosecutor Gaines did, that he was concerned about it not being successful and that we would be stuck with fees. And that is why he made the difficult decision not to pursue it at that time. However, with regards to the drug problem, you know, Sherrod Brown passed the bill Fend Off Fentanyl, and we were part and supported it extensively because it looks to hold, you know, traffickers of drugs and looks to impact their money laundering schemes. It is a very good bill. He got bipartisan support. We supported it, and we will continue to fight very hard to help addicts and those who have become addicted to drugs. You know, I support any efforts, which is why we have drug court, and which is why we have been an advocate and a supporter of drug court since its inception with Judge Durkin many years ago.
Okay.
If I can, she's absolutely wrong. We get none of the $330 million that Trumbull County was awarded and the $300 million that Lake County was awarded. Those were not class actions. The class action, One Ohio lawsuit, we do get proceeds out of. But Trumbull and Lake County filed their own actions, not a class action, and they were awarded $330 million. Mahoning County isn't going to see one penny of that.
And I can tell you, I know I used a class action as an example for fees assessed. I know about those lawsuits. The guys who filed them are my friends, and I know that Mahoning County is getting money from the opioid litigation and that we are using it in our Mental Health and Recovery Board, with whom our office, we represent the Mental Health and Recovery Board, so we're well aware of the good work that they do as well.
All right, we're going to move on. Okay. Gina, this goes to you first. A prosecutor's office deals with a lot of victims, and you have cases where families are sometimes not being notified of plea deals before they're offered, and you have victims who are hesitant to cooperate. How can a prosecutor's office do a better job communicating with victims?
Well, I can tell you what we did with regards to victims is we got the Matrix software program. So Marcy's Law is a statute that it requires that we communicate, collaborate with victims, keep them updated. They have a right to be at every proceeding. We notify them through the Matrix software. We also notify them. We have victim services coordinators that actually notify them and speak to victims. That works, and well, I do want to qualify. Our victim services coordinators in our common pleas court and our victim services coordinator in juvenile court notify of hearing dates. Our victim services coordinator in county court does not notify. That responsibility goes to the judge's bailiff. But we communicate with our victims all of the time. Once we added the software program, we were able to have those victims sign up for text alerts, email alerts, because sometimes we would be notifying through the mail. And we know since COVID, sometimes the mail just doesn't get to where it's supposed to be. So we do have other means and technology that we have introduced through our office in order to make sure that victims are notified. With regard to plea deals, we do discuss plea deals, and we are required to discuss plea deals with victims. We're required to get their input, and we're required to collaborate. Sometimes victims in our office, they don't always agree, but we do discuss. Sometimes you got to do what you know is in the best interest based on the evidence. It doesn't happen that often, but it does. But we do discuss the cases with them. We're required to do that, and we take their recommendations and their feelings very seriously.
Lynn.
Thank you. So I don't just practice in Mahoning County. I do practice in federal court, and I practice in the surrounding counties. First of all, Marcy's Law is not a statute. It is part of the Ohio Constitution, and it mandates responsibilities for the prosecutor's office. There is no other court in no other county where the bailiff is responsible for notifying the victim. That is the prosecutor's obligation. And in fact, we just had to continue a case last month when I went to county court, and nobody was certain if the victim had even been notified. Marcy's Law does require certain things to happen from the prosecutor's office, and quite frankly, I think the staffing for victim witness is significantly inadequate. I was at a town hall meeting where, unfortunately, a police officer was a victim of a crime. They had indicted and charged assault on a police officer, resisting arrest, obstruction of justice, and OVI. The prosecutor's office dismissed the assault on the police officer, the resisting arrest, and the obstruction of justice, and the individual pled only to the misdemeanor OVI. That victim, that police officer, found out about that in the newspaper. And when he approached the prosecutor at the town hall meeting to ask her why those charges were dismissed, she had no understanding of the case at all. Later, another prosecutor, assistant prosecutor, called that police officer and told him, we didn't think, in looking at the body cam, it rose to that level. There's two problems there. The body cam didn't change from when they took that case to the grand jury and indicted assault on a police officer, resisting an arrest, and obstructing. The body cams were the same. But more importantly, that officer had no idea those charges were being dismissed until after it happened. I hear that from lay people. I hear that from police officers. They're not kept in the loop. They're not notified. Certainly the prosecutor's office has discretion, but your question focused on how do you make sure they know what's happening? We need to do a better job of communicating with our victims so that when a case is done, everyone has confidence the right thing happened. So that communication process is failing at the common pleas level. It is failing at the county court level. That needs to be enhanced. Okay, that's one of the issues I've raised on the campaign trail over the past 18 months.
Okay, sure. Quick response?
Sure. I can assure you that the bailiffs in the county court are absolutely responsible for notifying victims. It is a procedure that they have implemented. My victim service coordinator is not responsible for that. The individual that my opponent is referencing was a case that I did get asked about. And we did, after learning and watching the body camera, we did have to make the difficult decision to dismiss a couple of those charges. And if I'm not mistaken, there may be some civil litigation coming out of that because it is not exactly how my opponent has made it out to be.
Right. We'll move on now to the next question. Lynn, this goes to you first. How should a prosecutor's office ensure that justice is served blindly, that no one is disproportionately prosecuted or sentenced due to external factors such as race or poverty?
Sure. That is an issue that is the topic of many law review articles, of many seminars, of many roundtable discussions. The disparity in charging functions and the vast power a prosecutor has in bringing charges. I've advocated, since I started running for prosecutor, a database to track, and Matrix is not a database to track charging and to track plea bargaining. We had a case on 680 where it was a drive-by shooting. The individual defendant said he was concerned because he was in a dispute with the people in the other car, so he shot at that car first and hit him, where 680 and 80 come in. Gun specifications are mandatory time that are added to a sentence. There was a 3-year gun specification that was reduced to a 1-year gun specification by the Mahoning County Prosecutor's Office. I can tell you, most of the shootings in the city of Youngstown and the ones on 680 are because families are feuding and there are disputes. On the inner city cases, those 3-year gun specs are not being reduced to 1-year gun spec. There is no consistency in Mahoning County on plea bargaining. On the murder cases, when they're reduced to manslaughter, the sentencing recommendations from the prosecutor's office are anywhere from 3 years to 26 years. That type of disparity for a manslaughter offense, quite frankly, shouldn't be happening. And if you look at the disparities that are occurring in plea bargaining, there are racial issues. In the Struthers death penalty case, where Rowan Sweeney was killed, there were many people involved in that. The individual sitting on the couch inside, charged with the death penalty. The 2 individuals that came up in the car, one charged with the death penalty, one was not because he was a juvenile. But there was a young woman sitting in that house. She also was texting and knew, and she destroyed evidence. 3 black men were charged. The white girl inside that house was not charged. We raised that in the course of the litigation, that you had multiple people clearly involved, and she was involved in destroying evidence and never had any charges brought against her. It comes from the discretion of the prosecutor's office, and you need someone that's attuned to those issues, that keeps a database, and that tracks those issues, so that disparity can not occur.
Gina.
So I can tell you, Lindsay, you know, we heard a lot about the different sentencing. You know, our office does make sentence recommendations. Crimes and different crimes carry different sentencing ranges. For instance, manslaughter has a range. It could range, without enhancements, it could range as a felony 1, 3 to 11 years. The same thing as an aggravated burglary, an aggravated robbery. We've got ranges. The reason why we have ranges is because under the sentencing guidelines, we're supposed to take into consideration a lot of different factors. They are criminal histories. They could be someone's veteran status, and that goes into making a recommendation. For instance, when I did the sentencing recommendation for Brandon Crump, okay, Brandon Crump was the actual shooter who executed Rowan Sweeney. I advocated for a higher amount of time based upon the mandated ranges that were on the case or on the charges that he was convicted of, because I felt that his criminal history, the way his criminal history supported that. And also it talks about success in diversion programs. That individual, Mr. Crump, had been offered diversion programs in a number of different instances and still continued to commit crime. We face these issues all the time. My opponent claims that there's racial issues involved in sentencing. Well, what I would submit to her is, please show me a case where a sentence was vacated because someone was a certain race or a certain salary range or a certain zip code. I have asked her, have you appealed cases based upon those factors? If we were doing that, Lindsay, if we were using race into play in our recommendations, and if the judges were using race into the sentences that they issued, then I'm sure we would be subject to many, many cases and litigation, because that would be inappropriate.
Can I respond to that?
Yes.
That shows a fundamental lack of understanding of appellate review of sentencing in Ohio. The 7th District Court of Appeals and the Ohio Supreme Court have said, as long as the sentence is in the statutory range, it will not be reversed or vacated. But more importantly, we raised the sentencing disparity in a constitutional motion to dismiss the death penalty, and her office stood up and said, we haven't even bothered reading those studies that confirm the disparity racially on the death penalty.
I do want to move on.
Lindsay,
We will get more into
just
this
one
topic.
final. It's interesting. So what I would say is that She says that there is race that goes into sentencing considerations, and I've said, show me a case, and then she says, well, there won't be a case as long as it's in the mandated range. So it just seems a little paradoxical.
All right, we'll move on because we have more to get into on that topic, but not just yet. First, Ms. DeGenova, this is to you. Last week, attorney Marty Desmond filed a request asking that a special prosecutor be appointed to investigate your alleged role in the firing of county employee Ricky Morrison.
Yes.
Now, the allegation is that Morrison was fired for supporting an opponent of a sitting commissioner and that you were aware of that but helped create a false narrative to cover up the reason for the firing, saying the commissioners had nothing to do with it and reinstating Morrison. Do you deny these allegations? And if so, what discussions did you have with the commissioners about this matter?
Well, I can tell you, Lindsay, I absolutely categorically deny them. And what's very sad is that the allegations that stem from Mr. Desmond's motion are statements that my estranged husband, whom I had to make the difficult decision to leave and file for divorce in August, told him. What's also very troubling, as I'm sure many people can understand, in a bad marriage, in an abusive marriage, that we often have to make decisions to leave. And that man, who has never had issues and never has made allegations until such time as I had to make the decision to walk out of the door, contacted my opponent, and my opponent took the call. And as a matter of fact, my opponent connected, I'm sorry, not my opponent, her close campaign advisor, connected my estranged husband to Mr. Desmond. And I just don't understand how someone would think that first of all, talking about someone's personal issues, about the most private things that go on in their lives, is something that should be used for political gain. That filing by Mr. Desmond is designed to help Ms. Morrow and County Commissioner Gino DeFabio. What's also sad is that my opponent and her advisor, Mr. Uhas, directed and connected my estranged husband to Mr. Desmond, knowing that he has a propensity to accuse people of crimes because he accused my opponent of manslaughter in 2016. This is absolutely heartbreaking to me, that not only had I had to leave a bad marriage and file for divorce, but that my opponent and members of her campaign are using my estranged husband to continue to victimize me. I have to tell you, those statements are untrue. And for me to have to even discuss this on a debate about my personal problems is alarming.
Ms. Morrow.
Thank you. First of all, I raised the impropriety of Attorney DeGenova's conduct long before her divorce, long before her husband reached out to anybody. The rules of professional conduct that govern lawyers' conduct apply to the prosecutors like they do private attorneys. We don't get to investigate our own clients. It's improper. It's wrong. And 18 months ago, I said, within 2 weeks of her taking office, Ricky Morrison was terminated. She investigated her clients and said they did nothing wrong. It wasn't politically motivated. I don't know if it was or was not. It was wrong for her to personally investigate this and clear her own client. And here's why it was wrong. She has touted the Mahoning County Prosecutor's Office as the largest law firm in Mahoning County. Let's run it that way. There isn't a law firm anywhere that would investigate their own client and exonerate them. Because here's the problem. If you investigate your own client and they did something wrong, you then have to turn them over. Shouldn't have ever happened. An independent investigation should have been done when Ricky Morrison was terminated, and then we would all have confidence in the outcome, and her soon-to-be ex-husband wouldn't be able to raise these issues. Now, addressing her false allegations that I've used this for any benefit, her ex-husband contacted me with a laundry list of things he wanted to raise, and my response was, I've run my campaign on the issues. I'm not going to fling mud. I have no desire to get involved in this. She keeps saying it was so improper to direct him to Marty Desmond. She knows Marty Desmond represented Ricky Morrison. And the response to her husband was, if you think something was done wrong in the Ricky Morrison investigation, if you have evidence of a cover-up, Why don't you go to Ricky Morrison's attorney? That's the bottom line. There's nothing nefarious or improper about saying, if you think something's wrong with that, go to the attorney that handled the case. Marty Desmond was Ricky Morrison's attorney when he filed the wrongful termination lawsuit. And despite her finding of no wrongdoing, the county paid $175,000 for his wrongful termination.
If I could address that.
Real briefly, yes.
Yes. So when my opponent talks about this alleged conflict that I had to investigate my own clients, this is not criminal misconduct that was alleged. And I can tell you who didn't think I had a conflict was Ricky Morrison's lawyer, Subodh Chandra. He contacted me directly on a Sunday in December and implored me, not anyone else, me, to do the investigation to look into. When we say investigation, it's a review. We're a lawyer. I'm supposed to review the matter. I did review the matter, Lindsay. I advised my clients that Mr. Morrison should be returned to work. He was returned with no loss in pay or health benefits.
All right, let's move forward. Ms. Morrow, you have criticized your opponent for allowing too many plea deals to be negotiated while she's been in office. But a plea deal is ultimately a conviction, and without them, it does create a backlog of cases. So if you win, what would you do different when it comes to plea deals, and why?
So let me clarify. I have not criticized plea bargaining. Plea bargaining is a critical component of the criminal justice system. 96% of our cases are resolved through plea bargaining. In the civil arena, it's the same thing. The vast majority of the cases are resolved through plea bargaining. What I have made abundantly clear is that in Mahoning County, unlike Trumbull, Columbiana, Portage, and Summit, we are plea bargaining away our most violent offenses. I've had 8 death penalty cases at the trial court level. She's had none. In 5 of those cases, they dismissed the death specification. We are wasting taxpayer dollars, hundreds of thousands of dollars, by charging high-level offenses and after 2 years dismissing them. Plea bargaining on your murder cases shouldn't happen at the rate it is in Mahoning County. It's not happening at that rate in Columbiana or Trumbull County. In Mahoning County, if you're charged with murder, you may get a life sentence in 24% of the cases because they're plea bargaining away the rest. Columbiana County, 75% of the time they get a life offense. Trumbull County, it's over 55%. So my criticism has been on the violent worst of the worst offenses, where you should be holding the line, where if you bring those charges, you should be prepared to go for the life sentence. Similarly with the death penalty, if you bring a death penalty specification, because not all murder cases are death penalty eligible, if you bring a death penalty specification, it shouldn't be dismissed like it is in Mahoning County after we spend $150,000. The delays, the dismissals, the continuances, and the plea bargains of our worst violent offenses are at a higher rate, double and triple, than any other county. That's what I've been critical of.
Ms. DeGenova.
Yes. So I do have to agree with my opponent when she says that I have not personally personally prosecuted a death penalty case. She is correct. I have not personally prosecuted a death penalty case. Neither has she. So, but I can tell you that we have very, very experienced and devoted attorneys in our office who has. Under my leadership, I haven't had to indict a death penalty case since I've been prosecutor. I can tell you also with the Columbiana County cases that she's talking about, Columbiana County in 2023 had 2 murder cases. One case was convicted as charged. The other was reduced to manslaughter. So they have a 50% rate of plea bargaining a murder case to manslaughter. The cases that she's talking about that although were not indicted under my watch, but the death specifications were dismissed, was involving the Rowan Sweeney case. Her client, Kamani Bryant, was charged with a death penalty specification in that case. We did agree to dismiss the death penalty specification in exchange for her client's agreement to testify against and in favor of Rowan Sweeney, to get Rowan Sweeney justice and give us the evidence that we needed to identify Brandon Crump as the actual shooter. We just didn't get up one day and say, I think I'm going to dismiss Kamani Bryant's death spec today. We did it as the result of a plea negotiations that we had to make, because what we really wanted to do was ensure that Rowan Sweeney's true shooter was brought to justice.
And as I mentioned, we were going to dive deeper into this topic, and we are now. So,
Can I respond to that?
Yeah, you may, yes.
The morning they indicted this case, less than a week after the homicide, they knew Kamani Bryant wasn't eligible for the death penalty. You get the death penalty if you're the actual shooter or if it's planned.
And we can continue because
neither one of those were present. They knew that.
This is the question. Let me ask the question.
Okay.
We can continue because we're not
Okay.
moving off of this topic
Okay,
whatsoever.
no problem.
So, Gina, this goes to you first, turning our attention now to the murder of 4-year-old Rowan Sweeney. In that case, the crime occurred on September 21st of 2020, and the first indictment was handed up on October 1st. Of the 4 defendants named, only 1 went to trial. Did bringing this case so quickly hurt your chances for a capital conviction?
Well, I didn't bring the case, Lindsay. So this case was indicted under the leadership of Paul Gaines. I wasn't a supervisor at the time. I had no role in it. So quite frankly, I can't speak to what I don't know and what I wasn't involved in. I wasn't involved in the decision. When I became prosecutor in 2023, I had to deal with the case as it was once it was under my leadership. And we did pursue Brandon Crump to the fullest extent of the law. That case had a lot of issues. It had a lot of delays. We had Andre McCoy, who went missing for 2 years. He was hiding. We couldn't find him. We also had witnesses that were all shot because when Brandon Crump bust through the door, he shot everyone there. The case was not the easiest to try, or not the easiest to navigate because of all of these issues. I can tell you that in the Kamani Bryant case alone, my opponent has spoke about continuances. She and her co-counsel sought 14 continuances or motions to extend deadlines in that case alone. I can also tell you that I believe it was this past June, if I'm not mistaken, there were pending motions, and my opponent said that she couldn't schedule a hearing during the month of June because she was busy baking cookies for a wedding. So there were delays in that case that were caused by cookie baking, by motions to continue, by the fact that there were people who were shot. And so we did obtain life sentences in every single well, I take that back. Life sentence for Kamani Bryant, a life sentence for Andre McCoy. We could not get a life sentence for Brandon Crump because of his age. So we did obtain the maximum result that we could. And I can tell you, the family of Rowan Sweeney still speak with us. And while they have lost their poor son, and while Rowan will never be returned, they are pleased with the sentences that were handed down for the individuals who took this young boy's life.
Lynn.
Thank you. So let's address a couple matters. When she took office, the first thing she said was, I have no plans to change a thing, and she hasn't. Rushing to indictment on a death penalty case when on the morning you're going to the grand jury, your witness tells you Kamani Bryant isn't the shooter, and still indicting him as the shooter is a travesty of justice. It's a waste of taxpayer dollars, over $150,000 wasted. Never should have been indicted as a death penalty case, could have been resolved much quicker. Yes, my daughter got married in June of this year, 3.5 years into the case. 14 continuances. Would you like to know what the Mahoning County Prosecutor's Office did in this death penalty case? After producing over 100,000 pages of records on an external hard drive, and then going back and double checking because they terminated the chief prosecutor on the case because she hadn't been turning over records, they reproduced the entire file, renamed all of the files, renumbered all of the pages, so we had another 100,000 pages of records that we couldn't tell what was a new production or what had been produced before. So yes, we had to start all over as 2 sole practitioners going through that entire file to see if there was any new evidence in there. because they played a huge shell game on us by reproducing everything in a different format. They didn't even keep the file names the same, so we couldn't look at the 2 hard drives to see, was this file on this hard drive? Yes, that took an awful lot of time to go through all of those and redo it. In addition to the DNA testing, where the state crime lab wouldn't agree to an external expert observing it. So there were 14 continuances, but had they just said, here are the new files the previous prosecutor hadn't produced to you, and not played games by relabeling the files, renumbering them, and rebate stamping the pages, we wouldn't have had to duplicate all of that work. And it was in the Mahoning Bryant case where we filed the constitutional motion to dismiss. She talks about the highly qualified staff. The attitude comes from the top down. They stood up in that, having had the motion for over 60 days, and said, we have no response to any of those constitutional arguments because we haven't read any of the studies on the state of Ohio's death penalty or any of the federal case law on the death penalty. That's not professional. That attitude comes from the top down.
Okay, quick rebuttal because we have to move on to
Yes,
the end.
actually, my opponent keeps saying I said I had no plans to change anything in the office. I meant the staff. I had said I wasn't planning on changing staff. I have changed quite a bit in the office since I've been prosecutor. Real quick, it
We have to
seems
get to
there's some
closing here one at a
excuses.
time.
I know, but there seems that there's some excuses for their delays. It may be reasonable, but I'm not the one that's been running on a platform of delay.
Moving on to our closings, there are 2 minutes total. Lynn, you're up first.
So when I stood up 2 years ago and said I was running, it was because I was disgusted at the delays, the dismissals, and cases being lost because the rules weren't followed. That response just now from the incumbent that it may be justified when you continually wait until a few days before trial to give a witness list or to give all of the evidence, and then you want to blame the defense attorney for saying, that's not what the law requires, we need a continuance, and say it's the defense attorneys, shows the flippant attitude towards the constitutional structure that was created hundreds of years ago to ensure justice. We don't have that in Mahoning County. It is a routine problem. Go on any docket when there's a trial set and the defense attorney requests a continuance, and you will see within a few days supplemental discovery from the state. That isn't how it's supposed to be. Too much gamesmanship in Mahoning County, too much disregard for the rules. We have a process in place to make sure that everyone has confidence in the outcome of a case when it's done. And far too often, because of the attitude from the top in Mahoning County, it isn't followed. When Judge Durkin continued a trial last summer, because 4 days before trial they still hadn't produced what they were required by law to produce, my opponent said, I don't understand what the big deal is. This was all stuff she really already had. That parroted what Paul Gaines has said years earlier when a murder case was dismissed because they didn't produce evidence, and a felonious assault case when they didn't produce evidence. This has to stop. I've handled over 500 felony cases, over 50 murder cases, over 8 death penalty cases at the trial court level, 3 in the Ohio Supreme Court. She's handled 3 felony cases. The attitude is coming from the top down, and it needs to change so that we don't have delays, dismissals, and cases lost. We are wasting hundreds of thousands of dollars because of a flippant attitude that the rules don't have to be
Time is
followed.
up.
Thank you, Lindsay. I appreciate the opportunity. I think my
It's okay.
my mic just
Keep going.
fell.
It's show business. Keep
Well,
going.
yeah, show
Yeah,
business.
yeah.
You know, I certainly appreciate the opportunity to be here. You know, when I decided to run for this office, people said, "Are you crazy? Get your head examined. Politics is horrible. It's a knife fight." I said, everyone likes me. I've been working here for 20 years. I'm a good person. I have a lot of friends. What could they say about me? Well, boy, I had no idea what was to come. You know, I'm a regular person. I'm a mom. I'm a daughter. I'm a colleague to some amazing people. in my office that despite the criticisms that my opponent has lodged at them, they're pretty amazing people. They come to work every day, they work hard to feed their families, they work hard to make sure that the victims of crime in our community have justice. I've handled over 2,500 matters in cases during my time as an assistant prosecutor, a chief assistant, and as the prosecutor. I work directly with law enforcement, which is why most of law enforcement has been supporting my campaign for prosecutor. I don't pull punches. I don't use gutter politics to gain political advantage by using the estranged husband in a bitter divorce who is mad because I had to make the difficult decision to leave for my safety and the safety of my own daughter. I can tell you this, Lindsay. If they thought that filing this lawsuit or this petition saying the most egregious things about me would hurt me and make me quit, they're wrong. I am here. I have dusted myself off, and I can't wait to continue to be the community's prosecutor. I am standing here to these listeners today, to the people who have watched this debate and who have watched me grow into my role as prosecutor. And I can assure you that if you vote for me in November, you will get the best staff with the highest experience and a devotion to this community. I will protect your families. I will do my job. And I am humbly asking for your vote in November.
Okay, I really appreciate both of you being here. It was a spirited and professional debate. Thank you so much for giving us your time and doing this debate with us here on the 21 News app. We were streaming live here on the app and also WFMJ.com. So you can go, as the viewer, go back and watch this debate. It'll be on the 21 News app, WFMJ.com. We also have a YouTube channel as well. And again, thank you so much for joining us here. It was a special debate. And 21 News is your place for politics. This is our promise to continue to report on the issues that matter most to you. Again, we really appreciate you joining us this evening.